Jury selection is now underway in James Crumbley's involuntary manslaughter trial, just weeks after his wife Jennifer was convicted of the same charges. Earlier today, we heard from criminal defense attorneys Richard Convertino and Terry Johnson about what to expect in this trial.
So for people who are watching this has had a lot of eyes on this case. It could be confusing to some that we're seeing the same judge presiding over both of these cases. Can you explain whether or not there are any issues with that?
Well, both defendants early on were charged criminally and were to be in the same trial. So there was going to be one trial with co-defendants in that trial. They moved for a motion to sever, asking that the trials be separated because they had incompatible defenses. So, and we saw some of that in the first trial where Jennifer used the empty chair defense to point to James as the responsible party in much of the criminality that occurred. So there's nothing unusual about a motion to sever with co-defendants. There's nothing unusual about the judge presiding over both cases independently. And there's nothing unusual about the cases being stacked seriatim one after another, even in close proximity for judicial resources. So the judge set aside that time, blocked the time out of her calendar in order to, save judicial resources and a judicial economy. So there's nothing inherently unique or unusual about any of that.
And Terry, do you see any conflict that at one point these two shared legal counsel?
Well, actually, I don't believe they shared legal counsel. I mean, I think that the two attorneys worked together. I don't know that both were representing mom and both were representing dad. But if that were the case initially, at some point they were, I'll say, severed off. Because at that point, as Richard just mentioned, the pointing the fingers at each other, you can't defend one and basically accuse the other if you're representing both. So at that point, early in the trial, it was severed. And when I say severed, I'm saying that one attorney went with mom, one attorney went with dad.
Now, what about the fact that we have another Oakland County jury in this case? That's something that they were arguing really hard to try to change, Rick.
They tried that in the first trial motion to move the trial to a change of venue, of course, and they also tried that in the second trial to no avail. So the standard is not whether or not a potential juror has heard of the case or even knows of the outcome of the first case. It's whether or not they can put aside their preconceived notions and be fair and impartial. That's the test. So that's a low bar, actually, unfortunately, for attorneys who are trying cases, because you often hear a juror in voir dire say, yes, I've heard of the case. Yeah, I'm aware that in the first trial the mother was convicted. I'm aware of that. I followed the case. Okay, that being said, the judge will say, can you put that aside and be fair and impartial? Yes, I can. It's unlikely that someone in that situation, just through common sense and experience, is unlikely that someone can put that aside. And so as a defense attorney, in this case, you'd have to use, or you'd want to use one of your, in this case, 8 preemptory strikes. And those are gold. You don't want to use those unless it's absolutely necessary. And one of the things that occurs when you use a preemptory strike is when you strike somebody, and they may be, I used to rate them 0 to 10, a potential juror. And when you strike somebody who's maybe a 4 or 5, that position is now open, and you might get a 2, someone worse, and that would cause you another preemptory strike. So it is three-dimensional chess, picking a jury. A lot goes into it, and as I said earlier, the most important thing that a trial attorney can bring to the selection of a jury is his or her collective experience.
And Terry, do you think that James will take the stand in his trial?
Great question. I don't know. That to me, if his defense attorney can do everything she needs to do and get his story out without putting him on the stand, great. To me, if you're putting a defendant on the stand, or the defendant decides to take the stand because ultimately it's their choice, you're behind the 8 ball. You're almost throwing up a Hail Mary. There are so many things that can go wrong, as we saw with Jennifer Crumbley, where you just ask one question, would you do anything different? Something so simple that it just destroys everything. Now, if she had never taken the stand, Would we have seen a different result? I don't know. But that's a great question. I would always say, stay tuned.
It is a great question. One quick thing to throw in the mix of this, I'm sure Terrence will agree. You know, to prep a defendant to testify is crucial, and my standard is 15 minutes of testimony equals an hour of preparatory time, and one of the hardest places to prepare a witness is the Oakland County Jail.
Any jail.
But Oakland County and Wayne County.
Yeah.
But Oakland County, it's difficult to get access to your client. It's difficult to have the opportunity to sit down and go through things carefully and for the length of time that you need.
What if we see some emotion out of him? You know, when Jennifer was on the stand, we really didn't see anything at all.
Again, it's going to come down to, is emotion a good thing or a bad thing? If he's crying, is he crying because he's sorry? Is he crying because he got caught? Is he crying because this is just a bad situation? I mean, it's going to come down to the interpretation of the jurors. And to me, the biggest thing that you can do, the best thing, is do everything you can to keep your client off the stand. If you start off like we saw in the last trial, when someone said, the defense attorney said, "You're going to hear from my client." Well, guess what? Everything else, it's like, yeah, whatever. We're just waiting for the dessert. We're waiting. We're waiting. And if she does that, if this attorney does that in this case, it's going to be probably the same outcome.
Yeah, I agree.
All right. Well, thank you both
We
so
agreed.
much
Look at that.
for being here. You agreed. We'll
Yeah.
end on that note. Thank you so much.